Anyway, I am very pleased to welcome everyone today to this program. My name is Dr. Beth Cooper Benjamin. I am Director of Programs and Peer Networks here at the Jewish Funders Network. And this is the September session of JFN's North America-based Gender Lens Philanthropy Peer Network. Some of you have been in prior sessions. Some of you may not have been to a Gender Lens Philanthropy event. We are thrilled to have you here. And especially really grateful to all of you for being here for this event today. Could not be more pressing and urgent and important for us to spend our time learning about. So I'm really glad that you all are taking time out from your rush to wrap things up in advance of Rosh Hashanah. Really appreciate it. And today we are here to discuss rights on trial, legal advocacy to protect women. I know that some of you work directly on this issue. Some of you have a personal interest in this issue. We are all going to be learning together from this wonderful team of presenters that we have joining us today, and I'm so grateful to them for sharing their expertise. And we're going to begin today by hearing from the illustrious Lisa Eisen, co-president of the Charles and Lynn Schusterman Family Philanthropies. Lisa happens to be a supporter of both of the organizations that we're going to hear from today. And in fact, the idea, the nexus for this program came to me from an article that I read in the 19th, which, if you are not a subscriber and a reader of the 19th, it is a gender lens nonprofit newsroom that covers current issues in politics and society and culture from an intersectional gender lens. And in my daily digest from the 19th, which is, I find, an invaluable resource for thinking about how gender shapes the impact of policy across a broad expanse of issues. I discovered this piece about a multi-state case challenging the Trump administration's restrictions on gender ideology, endorsing or supporting or promoting gender ideology on the basis that this was a violation of the Violence Against Women Act. And that then led me to Lauren and the work that she's doing with the National Women's Law Center. And we're really pleased to pair that with the work that NCJW is going to share, Darcy and Alex, about abortion access and legal advocacy around abortion. So we're looking at the courts and court strategy. And I am really pleased to welcome Lisa to talk about why this is also part of Schusterman's approach around reproductive rights and women's rights. So Lisa, I am very pleased to turn the floor over to you.
Thank you, Beth, and thanks to JFN for having me, but also for keeping this topic on the agenda. And I know Rebecca Serbu, who I just saw joined, has been an advocate and has been working hard, and now you, Beth, also to make sure that gender equity stays front and center in the JFN and broader funder community. So I'm really grateful. And I'm grateful to Darcy and Alex and Lauren for being here, but for your tenacity and your courage and all the other things that are needed to survive this moment. And we are also a funder of the 19th, who we met through the Equality Can't Wait challenge that we did together with Melinda Gates and Mackenzie Scott. And we just were super impressed with their vision, and we've been supporting them ever since. So, as you mentioned, we at Schusterman Fund both I actually, in my role as co-president of Schusterman, I oversee our Jewish giving, and I also oversee our gender and reproductive equity giving. And so we are funding both, and we fund these organizations and we fund litigation because we think all of this really hits all sides of our mission. Um, and is all comes from a place of Jewish values. You
Right.
cannot have a free and just society or a healthy democracy without gender and reproductive equity. It's core to the changes that we're trying to achieve in this country. The work impacts the Jewish future. The healthier our society and our democracy, the more that marginalized people, and I include women and all other marginalized people in that, are protected and treated equally, the more the Jewish community is going to have protection and the stronger our future will be. And this work is part of who we are. It's part of, protecting those who are more vulnerable, insisting on the dignity of all human beings. It's fundamental to who we are as Jews. So that's why we support this work, and it's part of our mission of achieving more just and inclusive societies. So I want to emphasize two messages just as a point of framing. The first is really strategic, tactical, which is litigation and legal advocacy are essential for this fight, especially in this moment. And we as funders are well positioned to help drive forward this kind of a strategy. I probably don't have to tell this group, but just to, make the implicit explicit, the people who are looking to undo or deny gender equity, I believe, are using it as the tip of the spear for undermining our democracy and consolidating their power. Um, there's a new report out called Gendering Authoritarianism, put out by the Berkeley Center for Othering and Belonging, I think. Gender is always used from Mussolini, up until today on as the forefront of undermining democracy and moving towards a more autocratic kind of a rule. And the people who are using it are well organized. They think long term. They think systematically, and they're working to enshrine their worldview into law. And that is why Schusterman supports C3 work, C4 work, electoral work, and including um, ramping up efforts to support litigation. The courts are an increasingly important arena, and it's where the struggle over access to reproductive health care and other civil and human rights is unfolding, and we have got to be there. Just to give you an idea of some of the places that Schusterman supports regarding litigation and legal advocacy, we support NCJW, we support National Women's Law Center. You're going to hear about their work. The Center for Reproductive Rights is also running actively about 20 cases with about 20 in their hopper right now. We fund Reproductive Freedom for All. They have 4 million members who are leading on advocacy for reproductive freedom and rights. Pregnancy Justice, representing women who are being criminalized for having an abortion or a miscarriage even. Even someone was put in jail for several months. Um, and we are also part of the Collaborative for Gender Reproductive Equity, and the Gender Equity Action Fund, their C4 arm, which have a whole judicial and court strategy at the state level, because that is where the battles are taking place. So I encourage everyone to keep an eye on this, but it is the way that we are really trying to mitigate the harm that's being perpetrated, and where we can to make progress and enshrine it in law. So it's really important to understand that at the state and local level, these cases are being used as trial balloons. The administration is testing the limits of their authority and before they can take these strategies to scale. And that's what makes fighting back now so important. So what I would say on this front is talk to your grantees, understand the policies, watch the legal threats and the legal challenges and the pushback against them. And if you can, use your resources and your networks to support litigation. And that's major cases, small cases. They're all signaling to people in power that they can't just get away with it. We're going to put sand in their wheels. And then my second message is a little bit more philosophical, which is Jewish funders should not be afraid to take up space as Jews in the fight for gender and reproductive rights. There's an Alice Walker quote that I like, which is that the most common way people give up their power is by thinking they don't have any. We are not powerless, quite the opposite. American Jews and especially American Jewish women have solid ground to stand on when it comes to these issues. We've been at the forefront of these fights. We have values, we have sacred texts, we have personal experience, and we need to stand up as Jews. And even though the spaces are not so comfortable for us right now, some of them. Um, it doesn't mean we can't have distinct strategies at Schusterman. We have a secular portfolio and we have a Jewish portfolio, but they do interact, and it all stems from the same set of Jewish values to pursue justice and make the world around us better and more compassionate. And so I think that's the beauty of Jewish philanthropy. We get to do both. We get to act on our universal values and our particular callings to defend gender equity and reproductive freedom. We can hold both. So, what's unfolding in the courts right now really matters. It's not glamorous. It's not always in the headlines, but it is incredibly consequential. And I think we're really at a fork in the road for our country. And when we talk about bending the arc of history, this is when we have to press down and make sure the curve moves towards justice. So, they think we're not going to notice as they're trying to slowly erode all of our rights and roll them back, but we are Jews in the pursuit of justice, and we notice, and we're going to fight back. So that is my opening framing, and I hope it's a good way to start the conversation.
Thank you so much, Lisa. I feel a little bolder and tougher after hearing from you. I really appreciate it, and I am so pleased. Well, before I move on, I want to invite everyone. We have a great turnout, so I'm so pleased to have everyone here. Those of you who joined as we were getting started, thank you so much for being here. We are going to turn it over to our presenters from NCJW and the National Women's Law Center. And I want to invite you all, if you have questions for Lisa, if you have questions for the presenters who are going to be speaking with us about specific legal cases and court advocacy, please feel free to drop questions in the chat, and we will pick them up as we move into Q&A. And certainly, if you have clarifying questions, we'll try and take things as we go along. This is a small enough group that we can really have a real conversation together. So I encourage you to pipe up. And as we get into Q&A, if you would rather ask a question on mic, feel free to raise your hand. But for now, I'm going to turn things over to our first presentation from Darcy Hirsch, who is Senior Director of Government Relations and Advocacy at the National Council of Jewish Women, and her colleague, Alexandra Lehman, who is Legislative Associate at NCJW. And I believe Darcy is going to speak first. So, Darcy, the floor is yours.
All right, can everybody hear me okay? Okay.
Yep.
Thank you, Beth. It's such a pleasure to be here, and I want to thank the Jewish Funders Network for putting together this timely program, and to all of you for joining us today. And it's nice to see some friends in the audience. And so, as Lisa framed so powerfully, this is truly a critical moment in time as we in the advocacy space navigate the ever-changing political landscape and work to protect the fundamental rights that we have fought long and hard for. It is so important for all of us to understand what is happening and how we can work together as a Jewish community and as a community more broadly to make a positive impact. So before we jump into the cases and the legal perspectives, I'll tell you a little bit about NCJW. We are a 132-year-old Jewish feminist civil rights organization working for equity and justice for women, children, and families in the United States and Israel. We are a 501c3 tax-exempt, nonpartisan, nonprofit organization, and we focus on issues, not candidates or political parties. We work to advance our priorities in a bipartisan way, working with policymakers on both sides of the aisle, and we work with the executive branch, no matter who is in the White House, to advance our priorities. These priorities fall into three broad categories informed by our Jewish values: reproductive rights, health, and justice, which we will discuss today; economic justice, which recently has included our advocacy against the cuts to healthcare and nutrition in the federal budget, and our celebration yesterday on Capitol Hill of the introduction of the Family Act, which would create for the first time ever a national paid leave program. Our third bucket is access to justice, which includes our work in the courts, our fight against anti-Semitism and hate, and also our work to help pass the Violence Against Women Act, which just celebrated its 31st anniversary last week, and you'll hear more about later on from Lauren. So how do we do our work? Direct lobbying, that's our team of lobbyists on Capitol Hill, meeting with members of Congress. Grassroots advocacy, engaging our network of 250,000 grassroots advocates around the country and our 46 NCJW sections. It's education. It's educating our advocates, clergy, congregations, and communities. And of course, through our work in federal state courts, our advocacy to ensure a fair, diverse, and independent judiciary through our Courts Matter campaign. It's serving as plaintiffs in cases or identifying plaintiffs, and it's leading or signing amicus briefs. There are times when certain strategies make more sense than others and are more effective than others. And of course, right now, the current makeup of Congress and the White House makes it nearly impossible to make progress on our priorities. And so we're taking a more defensive position, and we must lean into the courts. NCJW is the leading Jewish voice advocating for fair courts. As you see, inspired by our Jewish values, we want to create a federal judiciary that is fair, independent, and diverse, and reflective of our diverse community. We have long supported the nomination of important firsts on the bench, first women, first LGBTQ judges, first Israeli citizen judges, all kinds of judges that help make sure that our federal judiciary reflects the makeup of our community so that they can rule fairly. And we work across the country through our Courts Matter campaign to create a pipeline of qualified judges for the president to nominate, and we work with the Senate to support or oppose beneficial judges or harmful judges. And this is so important because judges who serve in lifetime seats on the federal courts make decisions that impact women, children, and families. From the schools we can attend to whom we can marry, federal judges impact every aspect of our lives. And we're seeing the impact of judges that we've helped confirm or worked on their nominations in putting a stop to some of the damage that could potentially be done over the last several months. So in addition to our work to diversify the judiciary, we also have a unique Jewish voice in the courts. Now, why is a Jewish voice important? When it comes to the law, Jews actually have an important and unique theological perspective that provides a legal basis to argue against unconstitutional laws, and specifically laws that reflect a narrow Christian view. In cases related to reproductive rights, to LGBTQ rights, to prayer in the schools, faith is being used to curtail these rights, and Jewish voices can provide a winning strategy. Alex will share about reproductive rights in just a moment, but before I turn to her, I want to share an example where a specifically Jewish perspective helped defeat state laws requiring that schools post the 10 Commandments in classrooms. And so you may or may not know this, but the 10 Commandments in the Torah are actually different than the Catholic and Protestant Bibles. And therefore, one cannot argue that the 10 Commandments are a neutral
Muted.
or historical text. And so In two recent cases, NCJW led the charge to help defeat these laws both in Louisiana and in Texas. In Louisiana, we mobilized an amicus brief on behalf of 21 diverse faith organizations saying that the Ten Commandments are not a universal text. And in Texas, we helped recruit a plaintiff, a rabbi who's actually an NCJW rabbi for repro, who represented that the Ten Commandments law in Texas classrooms was unconstitutional and an infringement on religious freedom. And so, as we move forward, I think it's really important that when we think about religious freedom, not only as a minority faith group do we have a unique perspective, but also specifically because of our Jewish perspective. So, to talk further about winning arguments based on our Jewish values, I'm very pleased to turn it over to my colleague, Alex.
Great. Well, thanks so much, Darcy, and thanks, Beth, for having us here today. It's a pleasure to speak with you all. So, building off of what Darcy mentioned, our uniquely Jewish perspective also equips us with a really impactful toolkit to bring the fight for abortion access to the courts. In fact, we have a secret weapon of sorts in that our reproductive freedom is deeply intertwined with our religious freedom. And for many decades, abortion opponents have successfully monopolized the faith perspective, creating a dangerous false dichotomy and effectively wielding religious freedom laws to curtail access to care. So, the US Constitution, along with many state constitutions across the country, have very strong and explicit protections for religious freedom, which can be understood through two components of the First Amendment. So, first, freedom from religious imposition. So, under the Establishment Clause, the government can't enshrine one particular theological interpretation in its laws. And second, the freedom to practice one's religion. So, with the Free Exercise Clause, we see that the government can't restrict religious practice without compelling interest. Now, Judaism strongly supports access to reproductive health care, including abortion. Our texts and teachings demonstrate that the health and well being of the pregnant person are paramount, superseding nearly every other religious obligation. So, when a pregnancy is life threatening, abortion is not just permitted, it's actually required. And centuries of rabbinical interpretation establish the importance of one's autonomy over their own body and health decisions. So, for example, as we approach Yom Kippur, I find it really interesting that scholars say even if 100 medical experts believe that a person is healthy enough to fast, if that person feels they are too sick to do so, we honor their agency and we let them eat. And similarly, reproductive freedom is essential for exercising this bodily autonomy. And unlike a particular Christian belief that life begins at conception, Judaism teaches that life actually begins at first breath. So until then, the fetus is considered a part of the mother's body without independent rights or life of its own. And unfortunately, right now, we're seeing that many abortion bans invoke this problematic belief that a fetus is a person, which we know is at odds with our religious understanding. So, in addition to our textual and theological support for abortion access, there's vast consensus among the Jewish community. And in fact, more American Jews believe in abortion access than any other religious group. So, when we fight for reproductive freedom, we do so not despite our religious beliefs, but because of them. So, today, we find ourselves in dangerous terrain. Since the Supreme Court struck down the constitutional right to abortion in its 2022 Dobbs decision, states across the country have implemented bans on reproductive health care, meaning that now 1 in 3, or 24 million, women of reproductive age in the US live in a state with an abortion ban. Now is the time to fight, and we need new tools. As Darcy mentioned, it's unlikely we'll achieve our legislative goals given the makeup of this current Congress, but that doesn't preclude meaningful action. We're turning to the courts, where we can bring targeted challenges to abortion bans. And to illustrate what this means in practice, I'll just briefly discuss 3 interesting cases that utilize this uniquely Jewish claim for reproductive freedom. So in Indiana, we saw plaintiffs, including Jewish women and an organization, the Hoosier Jews for Choice, file a class action complaint against Indiana's near total abortion ban. They claimed that the ban violated their rights under the state's religious freedom laws and explicitly cited the Jewish doctrine we discussed earlier. And when the legitimacy of the plaintiffs' religious beliefs was called into question, NCJW stepped in and filed 2 amicus briefs in their defense. And on appeal, the court affirmed the religious right to abortion, granting plaintiffs an exemption to the ban that was later upheld by the state Supreme Court. In Kentucky, 3 Jewish women filed a case arguing that the state's abortion ban, which defines life as beginning at fertilization, was unconstitutional. Specifically, they're claiming that the ban complicates and interferes with their ability to access in vitro fertilization, or IVF, which is essential to their faith-informed desire to grow their families, invoking the mandate to, quote, be fruitful and multiply. And actually, just recently in July, one of the plaintiffs, who is actively freezing embryos, was granted standing to continue with that challenge. And NCJW supports these efforts. And additionally, we join interfaith partners in a brief for a similar case in Kentucky. So, further bolstering the religious argument for abortion and its protections, specifically under the Kentucky Constitution. Lastly, in Wyoming, medical providers and reproductive health centers challenged the state's criminal abortion bans on both free exercise and establishment claims, citing that it unconstitutionally enshrined religious beliefs, again, such as life beginning at conception. So, in this particular case, to strengthen these arguments, NCJW scholar in residence Rabbi Danya Ruttenberg provided expert testimony, laying out and lending weight to the Jewish case for reproductive freedom. The court ultimately found that these bans were, in fact, unconstitutional, which then prompted retaliatory legislation. So this back and forth has continued, but now the third iteration of this case is pending before the state Supreme Court. So where do we go from here? These cases, in addition to many others across the country, show that religious freedom arguments can provide a compelling and, until recently, underutilized tool in the fight for abortion access. We at NCJW are continuing to closely monitor ongoing litigation and are poised to respond as laws continue to change. And this principle also guides our work beyond the courts. Our profound conviction that reproductive freedom is religious freedom shapes our efforts from the halls of Congress to our mobilization of thousands of advocates and clergy around the country. So, for example, this February, we will continue our tradition of celebrating Repro Shabbat, which is when we read the Torah portion that undergirds the Jewish belief in abortion access. And our 2,500 rabbis for Repro will take to the Bima to declare, indeed, reproductive freedom is religious freedom. And so the work continues. Thanks.
Thank you so much, Alex and Darcy. Wow, I have so many questions that I want to ask both of you. But I think we should continue on and put all of the pieces on the board here, and then we can open it up and have a broader conversation. So right now, please, if you all have questions for Darcy and Alex, please drop them in the chat and we will pick them up after our third presentation from Lauren Corey, who is Senior Director of Workplace Equality at the National Women's Law Center. I'm gonna spotlight Lauren. And Lauren, I'm gonna invite you to share about your work. While you speak, I'm gonna drop in the chat for everybody a link to the article from the 19th that profiled the case. And yes, Lisa, thank you for making the point that I had intended to make, which was that that Schusterman, this is a virtuous cycle of support where Schusterman has been supporting the work and also the mechanism by which the work is becoming known, and then it comes full circle and we get to talk about it here as a philanthropic endeavor. So I'm going to share that out while Lauren speaks for all of you to check out at a later time. But Lauren, for now, the floor is yours.
Thank you, Beth, and thank you all for having me here. I know we're in times where it is very easy to feel lonely, but I always feel more powerful when I'm in community with others. So it is very great to be here today. I work with the National Women's Law Center, as Beth mentioned, which is a nonprofit that fights for gender justice in the courts and public policy and in our society, sort of working across issues that are central to the lives of women and girls. And I really appreciate, Lisa, your ground setting. And one thing you said was that we cannot have a healthy and productive society without gender justice, which is always something that's important to name and hear, but I also think is a really perfect way to talk about the Violence Against Women Act, which is really a piece of legislation that passed 31 years ago, as Darcy mentioned, that was designed to do that in a way that is sort of unique, I think, in the way our laws work and in the way Congress is designed. Um, so I'll talk a little bit about that and then get to sort of what's happened over the last year and what our litigation has looked like. So as you know, VAWA, the Violence Against Women Act, was pa initially passed 31 years ago. And really central to this comprehensive approach, Congress created a broad set of grant programs for states, federally recognized state and territories, domestic violence and sexual assault coalitions, service providers, and tribes. And these programs have focused on a broad range of activities from preventing domestic violence and sexual assault to fostering collaboration between law enforcement and victim service providers, among other activities. And it really recognized that violence against women must be addressed within a broader framework and tailored to the unique needs of different women's experiences. For example, VAWA provides grants, among other things, for, and I quote, developing or improving the delivery of victim services to racial, cultural, ethnic, and language minorities. It also provides for judges to be trained on a broad range of issues from sexual assault and domestic violence to gender and racial stereotyping. It provides explicit protections for immigrants, including creating what are called T visas, which allow for certain non-citizen victims of human trafficking to remain in the US and apply for legal permanent residency. It defines underserved populations to include people with disabilities and all alienage status and age. It created programs to provide culturally and linguistically specific services for victims of domestic and sexual violence. And it also explicitly prohibits discrimination on the basis of sex, gender identity, and sexual orientation. And all of what I just mentioned was done with broad bipartisan support over the last 30 years across administrations and across congressional leaders from all political parties. And I would say, I think for good reason, while the work of VAWA is not yet complete, it has proven effective. When we look over the last 30 years since its enactment, the United States has seen domestic violence and sexual assault drop significantly. For example, from 1993 to 2022, annual domestic violence rates dropped by 67%, with the rate of rapes and sexual assaults declining by 56%, which are truly phenomenal numbers. Now, what we've seen happen this year, to sort of take a step back, since January of 2025, this administration has issued a series of executive orders that direct agencies to think about how they issue grants. That includes VAWA and all other grant programs that the government issues. One of those executive orders includes directing agencies to terminate all programs that include diversity, equity, inclusion, and accessibility programs. It also includes the directive to terminate equity-related grants and contracts. Another executive order includes a directive to eliminate, well, to eliminate any reference to what the administration calls gender ideology, which essentially directs agencies to eliminate programming, public materials, and messaging that doesn't follow what they have named as the policy of the United States to recognize two sexes, male and female, which are biologically defined. Now, what that has meant to the federal agencies tasked with implementing VAWA and other grant programs is that now we've seen them impose conditions on grant recipients that require the grant recipients to certify that they are not supporting or will not support diversity, equity, inclusion, or accessibility programs, to certify that they will not engage in gender ideology, and to certify that they won't serve undocumented immigrants, regardless of whether those services are required by law or essential to their mission or survivor care. And these conditions, I mean, this is in part why I wanted to start with the sort of the text of VAWA. Many of these conditions undermine Congress's intent in VAWA, threaten the effectiveness of these programs, and jeopardize the services that are being provided by two vulnerable communities across the country. Another thing that Lisa, that you mentioned when we started with, this is sort of the tip of the spear for undermining our democracy and concentrating power. The VAWA, it's in part, I am biased in saying this, but it's in part why I think these cases and VAWA is really special, and that VAWA is very specific in that you are meant to provide these services regardless of citizenship, regardless of race, religion, gender, in part because that's what's necessary to truly target domestic and sexual violence in our communities. And statutes matter, congressional intent matter. And while the executive has very many functions and is an equal but separate part of our government, it cannot ignore the law. Um, which is how in June, with our partners, with many wonderful partners, we filed a lawsuit on behalf of 17 state domestic violence and sexual assault organizations against the Department of Justice. And as we've seen additional agencies apply these same grant conditions to either VAWA or other social service administrative funding, that we've expanded the cases, and now on behalf of the same 17 organization sexual and domestic violence organizations, states, in addition to other organizations, we now have litigation against the Department of Housing and Urban Development and against the Department of Health and Human Services. And those three cases include claims that state that not only do these certifications violate the Constitution, in that the government is telling a domestic violence organization that if a transgender woman walks into the room and says, I need housing, I need support, that you're requiring that organization to refer to them by the wrong pronouns, to acknowledge them in a way that doesn't recognize their dignity and respect, which is a problem for building support and trust among an individual, but also a violation of the First Amendment. In addition to statutory claims, which include that essentially the Administrative Procedures Act, which gets at the point that I had mentioned before, that when Congress has said that this is the intent of the funding, it is for the executive to administer Congress's intent with VAWA. Um, I will say that too, that what has been really fascinating about this litigation in the first case against DOJ, once we filed the lawsuit, we were able to work out an agreement with the Department of Justice that they would not administer these grant conditions or require the plaintiffs to certify that they will follow these grant conditions until the court had had time to work it out. And while, ultimately our goal is that these conditions will never take effect, every day that a domestic or sexual violence housing organization, hotline, service provider stays open is a day that's good for these communities. So we've already seen that level of success. We're waiting to see how one court has issued a decision on our motion of preliminary injunction, our motion to pause the grant conditions against DOJ. A court has granted that motion, and currently the DOJ VAWA operated grants has been paused for all grant recipients that receive whose VAWA funding are administered through the Department of Justice, not just the 17 plaintiffs in the case, which is also a really wonderful victory. And we're awaiting a decision on a similar motion for our cases against HHS and HUD. I guess the last thing I'll say on this is I think that and then open to questions and looking forward to the discussion. What has been really challenging, I think, about litigation in this time is asking grant recipients who are afraid of retaliation in a lot of ways and who really rely on this funding to take a stand and file in court and put their name on a lawsuit and push back. And so seeing these little victories, knowing that there's a community of people behind them supporting, because I know that that's many people in this room, has really helped, I think, with the survival, both like with the morale in communities, but also uh, bolster the courage of people behind this. So it's sort of my long way of saying thank you for your work and thanks for being interested in these cases. And I look forward to any questions.
Thank you so much, Lauren. When we got together to prep this session, we talked about, how this was going to be an audience of really smart people, but who are by and large not attorneys. And so I was asking Darcy and Alex and Lauren to make sure that they were going to speak in a way that made the case law and the litigation accessible to everyone. And I'm so grateful to you for sharing it in the way you did. I feel like I've learned a ton about this work. And I'm very happy now to open it up for questions. Feel free to raise hands or drop a question in the chat. I have a question. This was something just to start us off, and Darcy, Alex, and Lauren, you can all jump in on this. One of the things that you mentioned, Darcy, as part of NCJW's work was about identifying plaintiffs. And I think this is like a kind of behind the scenes part of the process of bringing litigation that I think a lot of people don't really get to see or think about. And I think I would really love to hear from any or all of you um, about how that process works. Do you find a person first and figure out if they are I know there's this term about like the vehicle, the perfect vehicle for a legal challenge, or do you come up with a profile of a person based on the strongest legal argument and then go and try and find a person who fits that profile? This is very behind the scenes, but I'd love to get a sense of just how that process works.
So I'll jump in. I'll start if that's okay. That's such a great question, Beth. And I think that it really depends on the case. I mean, first of all, the person has to have standing, right? They have to be impacted in some way. And then they have to be able to articulate that impact in a way that will, kind of raise the alarm and raise the challenge. And so at NCJW, we work through our networks. We work through our sections around the country. We work through our rabbis and Jewish clergy for repro. Specifically when thinking about the New Orleans, sorry, we have a section in New Orleans, but the Louisiana case, our section had been involved in opposing the Ten Commandments legislation in the state legislature from beginning to end. They opposed it in the legislature. They urged the governor to veto it. And once it passed and was signed into law, they were involved. So we knew that we had engaged advocates who then had Jewish community members who could talk about in their depositions how having the Ten Commandments posted in a classroom impacts their children and their religious freedom and their ability to instruct their children in the way of their choosing. And then, in Texas, we work nationally with with the ACLU and a variety of other non-Jewish organizations that are working on church-state separation to oppose all of these similar laws in the states. And when, through our networks, we learned that we had worked to oppose the law in Texas also. And when it passed and was signed into law, we reached out to the ACLU immediately and said, we want to help find a plaintiff. And then when they were ready to bring the case, we reached out to our rabbis for repro. So it's that's just like kind of like the technicality of our longstanding involvement in the legislation through every part of the process and then bringing the claim. But then using our networks to identify a person. But the last thing I'll say, and then I'll turn it obviously to Alex and Lauren, is that when it comes to a faith claim, they have to have a legitimate religious belief. They have to be able to assert that this is a deeply held religious belief, that it's not just something like they're making up. And so that's like another aspect of it. I don't know if Alex, you want to elaborate on that one, and then Lauren, you speak further.
Sure. Thanks, Darcy. I think that's exactly right. And it's really a testament to the power of community and networks that were able to quickly identify these plaintiffs. For example, in that Kentucky case, of the three women who originally brought the suit, only one was granted standing because she was the only one actively freezing multiple embryos at the time. And similarly, when they testify to the conviction of their religious beliefs, they note their, for example, involvement in a synagogue, perhaps the kosher diet they keep. So showing the ways in which these religious obligations are tangibly manifested in their day-to-day lives. And similarly, that's where having an additional voice to verify those claims is useful. So I mentioned NCJW's scholar in residence, Rabbi Ruttenberg, who was able to provide this testimony. She spoke from the perspective of being a conservative rabbi, whereas the plaintiff was a conservative congregant. So she was able to specifically point to the sort of halachic teachings and the texts that actually like shape the day to day of that life. So, Lauren, I can turn it over to you, but hopefully that helps provide more light on the question.
Yeah, I'll add, I think it's similar. I mean, Darcy started with noting that it really depends. We've had some cases where the individuals will come to us first and note, like, something about this doesn't feel right. What do you think the legal claims could be here? And other cases where, we have an idea, we think something that's happening is illegal and wrong, but don't have the right person to fit it. And in some cases can't find the right person. And I think, Darcy and Alex probably have a really good handle on this, particularly given the nature of the cases that, particularly when you're dealing with individuals in this climate and on gender justice issues. Uh, I think there's a big barrier for fear of putting your name out there and having, being identified, particularly in these super personal ways that are required in gender justice and reproductive rights cases. So, but back to your question, it's a little bit of a mix.
Thank you. Well, we are starting to get some questions from our attendees. Toya, do you want to ask your question on Mike?
Sure. So thank you so much for organizing this conversation. It's really important and helpful to have the information. So my question was specifically towards NCJW, but for both. Where and how have you been able to build bridges with other religiously informed groups to advocate for reproductive justice? I think, Alex, you had mentioned something about that, and so wanted to hear more about it. And then a follow-up is what philanthropic support is helpful to nurture these types of collaborations, because I do think they're very necessary, because I think the right has falsely taken control of the conversation and the narrative. And we really do need to combat that from all sides because it's wrong.
That the second question might also be something Lisa might want to comment on, I imagine.
Yeah.
Can you say it again to make sure the philanthropic support part?
Yeah, just where and how can philanthropic support be helpful for these specific types of collaborations, bringing various groups together?
We often fund convenings. Sometimes we host convenings where we bring together the various organizations, and then we often will fund a convening where other partners are bringing people together to be at the same table. And that's a pretty low cost, high leverage investment, as opposed to giving, a significant grant to an organization or a group of organizations, paying to have them network together and hope that collaboration will come out of it is I think, a well-leveraged way. We try not to force collaboration because that's a little bit of a funder, I don't know, in my opinion, a little bit funder overreach, unless it's done really carefully. But creating the conditions for funders to collaborate, and sometimes we'll like support a community of practice, or we'll support some capacity building work that will enable them to create a table around a certain issue or around a certain, something. So I think that's one way. The other way is to support all these organizations. And sometimes if a collaboration becomes big enough, supporting the backbone. Because usually you need, if you've got multiple people at a table that you've been able to put together, you often need staff or a consultant to drive it. So paying for that as well is helpful. Um, so those are a couple of ways that I think philanthropy can use its various tools.
I can also jump in if that's all right. And thank you for this question. It's really thoughtful. And I think first and foremost, I just want to share that this collaboration across faith groups is so central to the work that we do at NCJW. In so many of the coalition tables we sit at, and so many of the projects we undertake, reaching across difference and taking this unified faith voice is really quite powerful. And in so much of our legal work, as I mentioned, some of these cases, we joined other faith groups in some of our cases or briefs that we filed to the Supreme Court this past term. Again, we joined faith leaders and advocates from many different religious traditions to show there's this broad consensus. In fact, there's a majority among the people of faith in this country who support abortion access. And beyond our court's work, actually, we recently launched a coalition called the Faithful Majority for Reproductive Freedom. So NCJW, along with other faith partners, are coming together to really intentionally flip this narrative, to reclaim this narrative through varied communication strategies as well as some policy work. So in doing so, we're trying to, again, cement our role that reproductive freedom is intertwined with religious freedom, and that we can again work with so many different faith partners in this work. And of course, support for that is always very welcome. But I know Darcy also can add to this.
No, I mean that Alex really summed it up. But to follow up on, right, so the Faithful Majority for Reproductive Freedom Coalition that we launched together with Catholics for Choice and with Sacred, kind of has two goals. One is coalition building. It's bringing interfaith groups together to talk about the similarities in our views on reproductive freedom. The other is that we launched message testing to find what messages are most resonant related to abortion access and reproductive freedom, and so that we could then use the results of that message testing to change the narrative, to create talking points and information that faith leaders, interfaith leaders around the country can then share to use to create culture change within their congregations, as well as when speaking out to lawmakers.
Lauren, do you want to add anything in here?
Yeah, I would just note, I agree with what Darcy and Alex and Lisa said, particularly about convening. The only thing I would add is making something that, we try to be very intentional about is not only working with interfaith leaders, but also ensuring that we're like lifting up voices and not and making sure that all of those voices are echoed in this movement and not just our own.
Thank you. Alan, I saw you had a hand up. Do you want to jump in? Oh, you're muted.
Thank you, Beth. This is actually a question maybe more for Lisa, and I don't mean to cause any offense to our friends at NCJW or National Women's Law Center, but let's say a donor who's not in the gender justice field at all wanted to explore, work there and also to show up explicitly Jewishly. What are the advantages of working through a partner like NCJW or working in the general secular spaces? As a Jewish organization and Jewish donor. I'm just curious how you think about that, because I have to say I find all of your work so compelling.
Thank you. When you say working with it, you mean like as a funder
As a
support?
funder, yeah, working with as a funder and supporter. Yeah, yeah.
I mean, we are very much a both and kind of a foundation. And so
Right.
the Jewish piece of it, we feel like that's part of our Jewish agenda.
Yeah.
NCJW and some of the other Jewish organizations are places where um, we can lead with the Jewish values, where there's a Jewish voice at the table,
Right.
the broader secular table. So we feel like, that's an important as part of our repro and gender equity
Right.
agenda. NCJW convenes tables and also, um, sits at a lot of tables representing. This from a secular point of view, I mean, just in terms of, we're one of the major funders of gender and reproductive equity in the
Right.
country. So it's hard for me to speak, what
Right.
we
For an
fund there
organization that
because
might be making
we,
a
we need a
single
broad
grant. Yeah.
platform. We need a
Yeah.
broad
Yeah.
platform to actually achieve the
Right.
the the goals and we fund economic opportunity and power. We fund safety and security, which so the VAWA
Right.
work is super important to us. And we've been involved with that. And um, that's actually something JWI also, I think, has been involved with. And so, we like to do both, but in terms of we have like a gender equity strategy within our Jewish portfolio,
Mhm.
but then broad, our broad portfolio covers a lot more bases. A
Yeah.
lot of it is state-based, a lot of it,
Right.
that kind of thing. I don't know
So
if I'm answering your question.
yeah, no, but I guess I'm curious. So when you show up in the broader field, especially in state-based efforts, and so much of philanthropy is really place-based. Most smaller donors really work in their community, their city, their state. Uh, are you able to show up Jewishly in
Yes,
spaces explicitly?
we do.
Yes.
We do, because that's who we are. We show
Right.
up as from our Jewish values with our Jewish name. And there are some spaces where we're not accepted,
Okay. Interesting. Yeah.
but it's the minority.
That's good to hear. That's yeah.
It's the minority.
Yeah. Thank you.
And thank you for the question, which, this is part of why we wanted to have this conversation across both Jewish and secular engagement and support around gender equity and defending women's rights. So I appreciate you jumping into the conversation. I know we are at time, and we could continue the conversation easily for another hour. And I hope that many of you will come back and join us for future sessions. The Gender Lens Philanthropy Group is shifting now to a quarterly meeting cadence. So we will see you all next sometime probably in January. I'm just going to drop in the chat our upcoming program calendar, which I hope you will check out because there's lots of good stuff that picks up primarily after the holidays. And I want to take just a moment to thank all of our speakers for joining us, Lauren and Alex and Darcy and Lisa. Thank you so much for sharing your time and your expertise and for walking us through this incredibly urgent work that you're doing. I'm so grateful to know that you are carrying these torches. And I want to wish everyone a sweet and just new year and some sweet time with your families and communities in the next weeks. Thank you all again for joining us, and we will see you soon.
Thank you, Shana Tova.